So in the previous lesson, what we did was spend some time talking about the pre-action protocols, specifically concerning the practice direction for the pre-action protocols, the sort of general document to which applies where there are no specific protocols that are in place concerning that particular course of action, that particular issue. This lesson is going to take a case study review at one of the specific pre-action protocols that exists. This one concerns judicial review claims. We're still talking about preliminary considerations, we're still talking about limitation and the pre-action protocols, and fundamentally, like I said, we'll spend some time talking at and looking at what one of these pre-action protocols actually looks like with a reference to a case study. I picked this one at random, ultimately, well, not too at random, I picked it at random, but also recognizing that I didn't want to do one that the various different textbooks had done, because of course that wouldn't be particularly helpful if I just did one that some other textbook has done. I wanted to try one that was different, and B, I didn't want to do one that was so niche and esoteric, an area of law that not many people even study, that is pointless to even think about. So I landed on judicial review, because that is something that of course you do need to understand when we think about public law, when we think about constitutional and administrative law. But feel free to, by the way, consult the Pre-Action Protocols website in order to find information about any of the types of claims you might wish to see. I'm going to list on the next slide what those claims are, all those protocols are, and then we'll get into the judicial review case study. So specific pre-action protocols concern the following different issues. Package travel claims. So if you wanted me to do one on that, then I'm sorry, you're sorely disappointed, I'm sure. Construction and engineering disputes, debt claims, media and communications claims, personal injury claims, clinical disputes, professional negligence, judicial review, of course, is what we're going to be doing here. Disease and illness claims, housing conditions claims specific to England and Wales, claims based on mortgage or home purchase plan arrears in respect of residential property, claims by social landlords, low-value personal injury claims in road traffic accidents, claims for damages in relation to the physical state of a commercial property at termination of a tenancy, low-value personal injury claims below small claims limit in road traffic accidents. So quite a few, okay, there's quite a few here, and again, like I said, some of them are very niche, very esoteric, but are very important because, of course, they are claims that come up and crop up at various different stages. So, for example, the sort of low-value small claims issues, and also road traffic accidents, and of course, a few concerning mortgages and residential properties and terminations of tenancies and all these different kinds of things, like housing and land law specifically. We're going to pick judicial review as one example of which we are going to examine. Essentially, just as with the general practice direction for the pre-action protocols, the protocols that are specific to judicial review claims will also set out the aims of the claim, aims of the protocol, also look at what constitutes good practice and what a successful judicial review claim might look like. If you want to know more about judicial review, of course, we have a series of videos on constitutional and administrative law more generally. We also are in the process at the moment of working through the constitutional and administrative law part of the SQE syllabus, so specific to the SQE if you want to see them as well. So let's think about this then. Paragraph 3 of the Judicial Review Pre-Action Protocol sets out the aims of the protocol, and it says that to enable parties to prospective claims to understand and properly identify the issues in dispute in the proposed claim and share information and relevant documents, to make informed decisions as to whether and how to proceed, to try and settle the dispute without proceeding or to reduce the issues in the dispute, to avoid unnecessary expense and keep down the costs of resolving the dispute, and to support the efficient management of proceedings where litigation cannot be avoided. Notice something very interesting. If you've got notes on the previous video, or if you've just watched the previous video, you might think, well, the aims of the judicial review protocol is very similar to the aims of the practice direction. And that's because ultimately the purpose of these protocols, the purpose of basically all of these preliminary considerations, whether it be limitation, whether it be course of action, jurisdiction issues, pre-action protocols, is to try and minimize the issue of disputes in litigation as much as possible. So ultimately, the general aims of all these protocols are the same, are basically ubiquitous. Okay, there are varying differences between different claims as it's tweaks to essentially fit that particular course of action, but fundamentally they all concern a similar idea. The idea is to try and ensure that the parties understand the positions of each other, the parties are able to make informed decisions about A, whether or not they should proceed, and B, how to proceed if they just choose to do so, to try and settle the dispute without proceeding or reducing the issues in the disputes. So things like ADR and things like settlements straight away, to avoid unnecessary expense and to keep down the costs of the disputes, and also to support the efficient management of proceedings where litigation may not be avoided. Paragraph 9 of the Pre-Action Protocol for Judicial Review makes it very clear, in fact, that the courts take the view that litigation should be the last resort. The parties should consider whether some form of alternative dispute resolution, ADR, or complaints procedure would be more sustainable than litigation, and if so, endeavour to agree to adopt, which to adopt. So again, ultimately, litigation is not a particularly useful tool for every single dispute. Just because you have a dispute does not necessarily mean that litigation is the best way of resolving said dispute. In most cases, litigation is the worst way of resolving these disputes because of the time it takes, the cost it takes. I'm essentially beating the same drum at this point, but I'm just illustrating to you the fundamental rationale of dispute settlement in England and Wales. As with the practice direction, there is also the requirement, or the expectation, should I say, that there is a letter that is written and that is sent before a claim. In good time before making a claim, the claimant should send a letter to the defendant. The purpose of this letter is to identify the issues in dispute and to establish whether they can be narrowed or litigation can be avoided. Again, illustrating this point about litigation being avoided. Ultimately then, the aim of the Judicial Review Pre-Action Protocol, the PAP, as I've eloquently illustrated it there, is to, just like I've said before, limit insofar as possible the need for litigation. It's quite ironic that the majority of this course on dispute resolution is going to be about litigation, is going to be about all the rules concerning litigation and all the evidentiary procedures, when ultimately nobody really wants to go to litigation. But of course, litigation in some cases is unavoidable. So the aim is to reduce litigation, and the purpose of this is, of course, cost saving and time saving, and it encourages the use of ADR where a dispute may not require litigation. If you would like me to do some more of these pre-action protocol case studies looking at other areas of the law, fundamentally they are very similar, so I would shy away from doing so. But if you really want me to, let me know in the comments down below, and I'll do some more. But for now, what I'm going to do in the next videos is just wrap up these sort of preliminary consideration things concerning things like parties to a claim, cause of actions, and jurisdiction, and then we will actually start thinking about civil litigation as its own concept throughout the rest of these videos.